for the same team, for Watson's team. And his name was Craig Venter. Now, you've heard of Craig Venter. And who hasn't heard of Craig Venter? Okay. Craig Venter is a very famous man. He started a company called Celera, and they were going to be the private competitor to the publicly funded Human Genome Project. But that was much later. He actually taught at the University of Buffalo, where Peter, Lisa, and I are all alums of. He was in the pharmacy department for a while, and nobody liked him that I know of. But he is a very famous man who has done great things. I don't want to detract from his greatness. And he actually did do a lot to spur along the race for completing the human genome, because he helped to develop a new method, a really important new method to rapidly sequence genes. The whole genome shotgun method, which relies on computing power. It's a great, if you're a geek, go read about it. I'm not going to describe it here. But that was a great innovation. Now, when he was working for Watson as part of the Human Genome Project in '92, he and another couple of people in the NIH thought, wow, when we get these things, when we find genes, and they were looking for express sequence tags, which delineate the ends of genes, what we should do is we should file patents on these things, because they could become valuable in the future. James Watson, well, first of all, Bernadine Healy, who was James Watson's boss at the time, thought this was a great idea. When James Watson got word of it, he bitterly complained. He has a temper, apparently, and he yelled and screamed that this couldn't happen. You can't do this. He was just going to blow a stack over this. It didn't make him happy, in a sense. And when Bernadine Healy discovered his unhappiness because of his very vocal opposition to it, she fired him. So he was no longer in charge of the HGP in the US. Francis Collins then became the head of that, and he's now going to be head of NIH. So a little historical background to put it in perspective. Venter went on, founded a company, a private company, Celera, which I already talked about, and as they began to sequence the human genome, guess what they did? Patented the hell out of it. So they started filing patents left and right. Other companies, Insight and a couple other companies, really got into the act. And the short story, short story of it is that today about 20% of the human genome is patented. So 20% of genes have some patent claim filed on them. A gene is an arrangement of nucleotides that codes for a protein. A little bit of science. Its action involves the creation of proteins by mRNA, messenger RNA, which as it creates the proteins, reads the beginning and end of the gene and leaves out the introns. Now, this is a natural process. This is how you are made. You are composed of proteins that are read through this process, okay, and produced in different cells according to differentiation of those cells, again, through the instructions of your DNA. It is the same mechanism as that which scientists use to create what they call isolated and purified genes. All right, cDNA. That's important. A patent on cDNA is, I argue, not different than a patent on a gene itself. There's nothing new about the cDNA. All right? That's, as I said, the process for creating cDNA is the transcription process that goes on all the time. Nature devised this. It isn't anything new. It's not novel, and it's not properly patentable. But I'm not here to make the legal argument. So don't let's get tripped up on that, because I have another argument about this that has to do with ethics. We can debate it later. My friend Luigi Palombi has an excellent book, which I recommend. It's called gene cartels, and he really tears apart all of the legal arguments on the other side of the debate. So if any of you want to debate that, I'll ask him to step up here and talk about that. Let's talk about the ethics. There are two types of commons. Now, this is, again, an area where we need to get clear on the terminology, because you and I, we were trained as lawyers, and we think of commons as something that it turns out, as I think, a little bit oversimplified. We think of the commons as a creature of positive law, all right? That we carve out commons out of things that might otherwise be ownable or possessible. But that's only one particular type of commons, I argue. So a national park, right? National highway systems, international waters. Could any of those things be enclosed and possessed to the exclusion of others? All of them could, absolutely, right? And in fact, a lot of commons, right, of those sorts, national parks, highways, et cetera, they have to be reclaimed from individuals, right, by the state, and then turned into a commons. That sort of commons, when you take something that could be owned and possessed, right, to the exclusion of others, and carve that out and then set it aside for the common good, that is what I'd say is a commons by choice. And I talk about that in chapter 7 of my book. There's another sort of commons, and that is a commons by necessity. And this is a little trickier. Are there parts of the world that simply cannot be possessed in any meaningful way? They can't be enclosed. They can't be subject to the, remember how I described the justice, the grounding of rights to possession over certain things, right? Are there parts of the universe that are unsusceptible to that sort of grounding? And I claim that there are. These are, I would say, commons by necessity. And here's a couple examples. All of the oxygen in the atmosphere. Okay? The element oxygen. All right? Laws of nature. Bands of the radio spectrum. I like this one. This was the one a lot of IP theorists argue about all the time. Is there any way for me to exclusively possess a band of the radio spectrum? What do you think? What can I do? If I want to exert my control over a band of the radio spectrum, I build a radio tower and I start broadcasting on a particular band, right? And then you come along and you want to exert your control over it, and what do? You pump up the volume, right? You turn up the wattage, and then we end up with a battle, right? And this is what a lot of economists call the tragedy of the commons, right? Is when everybody's fighting for one of these things that is supposed to be to everyone's benefit. But I don't think most of the discussions account for the fact that there are these two different types of commons, and we can choose to treat them. We can choose to treat commons by choice in one way, but we have no choice over commons by necessity. Okay? Anybody have any questions about this so far? Again, we can debate it after I'm done. I argue that the human genome itself is a commons by necessity. It is a constantly evolving object that involves every member of a species. And like outer space, like the atmosphere, like sunlight, like laws of nature, and like radio spectra, it cannot be enclosed to the exclusion of others, simply as a matter of necessity, not as a it's just logically impossible to conceive of this. Okay? And in fact, we prove this all the time, right? So if somebody wants to come along and reproduce a gene, what do they do? One of these 20% of the genes that are patented. Do you have any control over your present violation of the patent law? Or you could stop yourselves replicating, right? Yeah. You can try to do that, and you can try not to breed, et cetera. Anyway, this unenclosable object is constant.